Well, basically, a will is governed by an act of parliament, or a will or a testament, a testamentary disposition is governed by the Wills Act 1971, Act 360. That is the law that governs the creation of a will. For instance, you wake up in the morning, your wife looks at you whilst wearing her nightie, comes to stand before you, Mr. Jakpata. I did you good last night. And as such, your properties are Trasaco and at Airport Hills. You know I'm your only wife. Please bequeath this property to me.
I don't have property in Trasaco.
Yes. That is how come when people say that, well, don't use this property for this when I'm no more.
Yeah.
When the property becomes vested in me, I can decide to sell it.
Yeah.
I can decide to do whatever I want with the said property. So clearly, when you are alive, you have to enjoy your money. Yes.
Hello, Mr. Jakpata here, your host for Port Valley TV. Today, my guest is George Annan-Prah Esq. We have been friends for 25 years now. Today, he's gracing us with his presence. We are going to discuss, well, in case you are having a property, you have a wife, you have kids, what you need to leave behind if you are no more. Let's welcome our guest. Okay, welcome, George, to the show.
Thank you very much, Mr. Jakpata.
George, tell us about yourself.
Okay, so for what I can say now, I'm a private legal practitioner practicing in Accra in the chambers of Aqua Sampson and Associates in Adabraka. Mainly, we deal with land matters, matrimonial matters, and also we do a lot of probate and administrative issues in Ghana. So basically, that's what I currently do.
Okay, so I want to find out about something. So if, let's say, a poor man has no money or has no cash, can he do a will?
Basically, we need to first understand what a will is for us to put the question you asked in context.
Okay.
Now, basically, one may ask, what is a will? A will basically is a declaration of one's intention about how his affairs should be conducted or managed after his death. So, per the definition, the broad definition of what a will is, you can then see that it goes beyond the distribution of one's properties and also has to do with one's affairs upon his death. So yes, whether or not you die with money or not, you can still make a will in respect of certain aspects of your life after you are dead and gone.
Okay, so my next, can I ask, so what inspired you to pursue a career in law?
Okay, so after my first degree, I had a conversation with my uncle, who is a professor at the University of Cape Coast. I went to his office to inform him that I'm done with my first degree and I needed advice since he had accomplished a lot by then. So he asked myself, George, what do you think you can do, or what profession do you think you can take up? Because looking at the job market and how difficult it is for new entrants to get meaningful jobs, you need to get a career or a profession. I'd done my BSc Geography and Regional Planning. I had intentions of probably being a GIS expert, that's Geographical Information Systems. That's sometime in 2012. That was, quite, an innovative, sphere one could actually embark on. But, I went through, and I think just around that time was when the election petition between Akufo-Addo and Mahama was being televised publicly for all of us to have at first hand the nuances of courts in, for the first time. So I took an interest in that. And obviously I watched movies as well, that actually, elicited certain interest in me that, well, I think I have what it takes to read law. So yes, I took it into consideration, and then I actually took steps to pursue it. It wasn't an easy, journey. It started from a point. There were disappointments. There were instances where I had to take breaks to also go into life and do other things. So yes, it's been a long journey, but we all can only thank God that we went through life and also went through law school and studied law as well. So we are guided by life events and also guided by the law. Yes.
Okay, congratulations once again.
Thank you very much.
And let's go back to topic. So, how does one get create a valid will in Ghana?
Well, basically, a will is governed by an act of parliament, or a will or a testament, a testamentary disposition is governed by the Wills Act 1971, Act 360. That is the law that governs the creation of a will. Now, the law itself provides certain requirements that must be met by a person who intends to create a will. Now, the first and most important requirement has to do with capacity. Now, when we talk about capacity in law, it means whether or not you have the authority to do something. And depending on the law that creates the said capacity, it provides that requirement. Now, when you look under the Wills Act, it says that for a person to create a will, that person ought to be at least 18 years of age. So you can be as rich as Elon Musk, but if you do not meet the requirement of 18 years, if you even create a will, it is seen as a nullity because you do not meet that requirement that the law provides under the Wills Act. Now, there's an exception to this rule that you ought to be 18 years to enable you create a will. And that exception only has to do with a person who serves in the armed forces and who at the time of his death was below the age of 18. So that is the first requirement. Now, it also ought to be a voluntary act of the person. Now, when we talk about voluntariness in respect of the creation or an execution of a will, it must be from the free will of the said testator, i.e., you should not be unduly influenced in creating a will. For instance, you wake up in the morning, your wife looks at you whilst wearing her nightie, comes to stand before you, Mr. Jakpata. I did you good last night. And as such, your properties are Trasaco and at Airport Hills. You know I'm your only wife. Please bequeath this property to me.
I don't have property in Trasaco. I beg you.
Yes. So, also, looking at the circumstances, you are being unduly, yes, and then invariably go ahead to execute that will in her favor. It is not your voluntary act, and as such, that particular disposition or that particular property you gave to your wife, right, can be set aside. Not that the whole will be set aside.
Okay.
That particular disposition you made to her can be set aside. And also there's the need to be in the right frame of mind, or you must be lucid to be able to create a will. If you are suffering from any form of insanity, that could vitiate that requirement and the law of you being of sound mind to create a will. So at the time of creating the will, you shouldn't be drunk. I'm putting those words loosely, but there's a legal requirement that you need to be lucid. Now, you can be suffering from an insanity, undergoing medical treatment, but if at the time you made the will, you understood what you were doing, then the will be valid. In as much as you have been suffering from insanity over a period, if at the time you made the will, you were lucid, you were sane at the time of making the will, then that particular will would be valid. Yes. And also, there are instances where you want to appoint certain persons to act for and on your behalf upon your death. That is by appointing trustees and by appointing executors. So the will provides you the opportunity to elect those persons who would act for and on your behalf as your personal representatives upon your death. Now, this thing is not new to us. Under customary law, when the person dies, the family, after the burial of the person or before the person is buried, have a meeting and elect customary successors. Now, what the Wills Act provides is that you, the person, can elect who you want to act as your executor upon your death. So that is one unique thing about you creating a will. If you have a company, you can elect trustees, you can elect executors who would manage your company when you are no more. So having a will is very important. Even how your burial should be held. Some people are very meticulous. They even in their will state clearly the songs that must be sung at their burial, the food that must be shared, and certain persons who should and should not attend their funerals. So the law gives you an area of opportunities to put certain things right before you go to your maker. So yes, a will is very essential and very, very important thing that one should actually avert his mind to whilst he engages in active life.
So my next question: can I have a will with my wife, like a joint will?
Is it permissible? It is. Is it advisable? I may not advise that you have a joint will with your spouse. However, there are certain properties that you acquire with her during the subsistence of your marriage, and by operation of law, your spouse might have an equitable interest in the said property. So whether or not you have a joint will or not, she still has an interest in the property. So it is your interest in that said property that you need to think about, because for her, the law provides for her and she's catered for. So it's your affairs, your personal affairs after you are no more. However, you could bequeath all your properties to your wife. The law doesn't frown on that. You could go ahead and bequeath all your properties to your wife. If that is what makes you happy, you could do that.
So what would be your advice? So you're having a will. So is it advisable to let a family member, or as you said, there needs to be
An executor.
an executor? So now the executor is dead. What happens?
So now, where the executor predeceased the testator, i.e., the one who made the will, right, leaves whilst the executor to the will is dead. It gives you an opportunity as the testator to make changes to your will because you are aware that your executor is no more. So in instances like this, you either execute a codicil, i.e., a supplementary will, or you revoke the will expressly and come up with a new will where you appoint someone much younger, someone you believe has what it takes to administer your estate when you are no more. Because the duties of an executor or an administrator of an estate is provided by law. And it's most people are not even aware they are named executors in a will. They only get to know that they've been named as an executor in a will when the will is being read. And rather unfortunately, if you are named as an executor in a will, you have to perform your duties under law unless you expressly revoke that duty that has been imposed on you by the testator. And then with that, we would then look at the beneficiaries, or we rely on the PNDC law 111 to look at persons who can apply to the court to administer the estate for and on your behalf when you are no more.
Okay, can divorce revoke a will?
Now, okay, so divorce necessarily cannot revoke a will. If the provisions made in the will are express in itself, right? So for instance, in a will, you state in 2025 that I bequeath my property at Trasaco to my wife, right? And you divorce your wife in 2027, and then you remarry in 2020, let's say 2030. You marry another woman in 2030, and then you die, and then your will is read. Now the question will be, what was the intention at the time you created the will? Was it to that specific person or to the person you were married to at the time of your death? So my advice is, if an event occurs and you think it's adverse to any provision in your will or any dispositions you've made in your will, you should immediately take steps to either amend or revoke that particular provision. Because if, for instance, you mention the person's name categorically and you fail to revoke that will or that particular provision of that will, that person is entitled to that particular provision in that will. So it matters not. So there are instances where people create wills and they bequeath all their properties to their family members. The law will give effect to it. As long as the will is valid, the law will give effect to it. So in constructing your will, your words should be express and succinct so that we can actually know exactly what your intentions were at the time of making the will.
Now let me go to the layman's. For instance, there's a will, but I don't disagree with the will. Can I take it to court?
Now, okay, so let me put it this way. Let me answer it in phases. Now, a will only takes effect upon the death of the testator.
Okay.
If the person who made the will is still alive, it is just a mere declaration of his intention of how things should be handled upon his death. Now, so upon his death, if, for instance, you have an issue with any provision in the will, you could go to court and then, based on the issues you raise in court, the court thinks they find merit with them, they could give you a ruling in respect of that.
So what happens if one dies without a will?
So now, in the event that one dies without executing a valid will, then it would be termed as the person dying intestate. You can even execute a will and still die intestate if certain provisions in your will are rendered invalid. Right? So where you die intestate, your estate is governed by PNDC Law 111. That's the Interstate Succession Act, where it gives or provides how your property ought to be distributed. Yes. So if you execute a will, you die testate. If you fail to execute a valid will, or you do not execute a will at all, then we can say you died intestate. And then your estate will be governed by PNDC Law 111.
So with the Will Act, are there types of will concerned in Ghana?
Invariably, it's the requirements provided by the Wills Act clearly state that a will ought to be made by a testator, and it must conform with the requirements provided for in the Wills Act, i.e., it must be in writing. The person executing the will must have capacity, must be sane, must be able to appoint people to act as executors and whatnot. So, in terms of types of will, broadly, there's just one type of will, which the Wills Act provides for. Yes.
Okay, so let's say I have a daughter,
Okay.
and let's say one daughter, and you see like his the dad is dead.
Yes.
Now, when they are reading the will, the daughter is expecting that every property is being willed to her. But in the reading of the will, she finds out that the will, the properties has been given to his nephews and nieces and strangers. How does she find the authenticated? How does she feel that the will is valid? The person reading the will, is it from the dad or is just a fabricated will?
Okay, so let me answer it in a scenario. Now, a will in itself is a legal document. And aside being a legal document, it's always advisable to get a lawyer to help you prepare your will. Now, where a lawyer helps in preparing a will, some of these questions in respect of the validity of a will is kept, because the lawyer would know or would take the testator through the right process in executing the will. Now, the lawyer is not there to tell the testator who he has or who he should bequeath a property to. His duty is to assist the testator in complying with the requirements that the law provides. Now, a testator is at liberty to bequeath his property to anybody he deems fit. There's no requirement under law that states that you ought to bequeath your properties to your children, your wife, or your mother. The only exception under the Wills Act is where the child is under the age of 18 and a deprivation of the said child would cause him hardship. Then the court would make a reasonable provision from the estate to the said child. So if you are a child of a testator and you are more than the age of 18, that particular exception cannot save you. Your saving grace would be that in the residuary clauses of the will, certain provisions are made, and then with that, the Interstate Succession Act might step in, and then you might be saved. But if the will is validly executed and you cannot show any elements of fraud in the execution of the said will, rather unfortunately, you cannot overturn a validly executed will. So my advice would be to the young ones out there is not to feel so entitled to the properties of their parents. As long as the properties are acquired by the parent, they can decide what to do with it. And you cannot tell your father that he ought to have bequeathed his estate to you. You should also strive and work hard and also acquire your properties yourself. If you are fortunate and your father grants you some of his estate, you thank him. If he dies intestate, then the law provides a provision for you. You can benefit from his estate. But in the event that he executes a valid will and decides to give his properties to some other person, then rather unfortunately, you cannot lay claims to them unless you can prove that the said will was executed fraudulently. Yes.
We've been hearing a lot about letters of administration.
Yes.
When one dies, what are they?
So now, where one dies intestate, i.e., dies without a will, the personal representatives or administrators are the persons who apply to court for letters of administration. Now, the Interstate Succession Act provides for the primary persons who can apply to the court for letters of administration. Now, under the Interstate Succession Act, the primary persons who can apply to the courts for letters of administration are the spouse, the surviving spouse of the deceased person, the children of the deceased person, the customary successor of the deceased person, or the family head of the deceased person. However, it's always advisable that more than one person or more than one of the category of primary applicants jointly apply to the court for the court to grant them the letters of administration to administer the estate of the deceased. Yes, so it is a way of seeking the authority of the court to deal with the estate of a deceased person.
So it means no one outside the primary.
It is only when the persons who by law are required to apply to the court are refusing or neglecting to apply to the court. Then, as a beneficiary under the said estate, you can then make an application to the court, and then in your affidavit in support to your application, you depose the fact that the primary beneficiaries or the primary persons who ought to apply to the court for letters of administration have reneged on their obligation to do so, and as such, you are praying to the court to grant you letters to administer the estate of the deceased person.
So how do you know a beneficiary of an estate qualified to apply?
So that is why the law provides that a spouse, a child, the customary successor elected by the immediate family of the said person. Now, an easy way to ascertain who these persons are is the obituary that is produced or published when a person passes on. Yes. So in the event that someone passes on, the primary document that everyone looks at is the obituary. If your name is not listed as a child on the said obituary, it will be very difficult to prove to the court that indeed you're a child of the deceased person. So those are some of the primary documents that the court will rely on in actually establishing that, well, you are indeed a child. So the difficulty some people also encounter when they make such applications, the court would require, for instance, a man married under customary law with more than one wife, and then only one of the wives decides to apply to the court to be granted letters of administration to the estate, the court would not accept such an application because they know how people have abused some of these things. Because ordinarily, some people have the mindset that when I am a named administrator of an estate, or I become an executor of an estate, I become the owner. No. Whereas that is not what the law provides. You are just to administer, basically share the properties in accordance with law or in accordance with the will of the person. Yes. So depending on the nature or the circumstances that you might find yourself, maybe 15 children, and just 2 of the 15 apply to the court to be granted letters of administration. Invariably, the judge will ask questions.
Yes.
Whether or not these 2 children are representing all the 15. And if so, then they ought to depose to an affidavit consenting to the grant of the said letters of administration to the court. Recently, I did a case at the Bachona court, the district court here. It was an application for letters of administration. Unfortunately, the surviving spouse was bedridden. Right. But the judge was of the view that as long as there's a surviving spouse, whether or not he was bedridden, he ought to consent to the grant of the letters of administration to the surviving children, who were 2 women. So we had to go back, get the spouse who was bedridden to consent to the grant of the said letters of administration before the court went ahead to grant that said letters of administration. So it's quite depending on how
the scenarios are.
Yes.
So can the property acquired through succession be willed to another person?
Yeah. So now, where an executor is appointed, or when one is elected as an administrator of an estate, your duty is to administer the estate. Now, by administering the estate, you ought to execute a vesting assent based on the authority or the powers that the court gives you as an executor or an administrator. You then execute the vesting assent to vest the property into the lawful beneficiary under the said estate. So when the property is validly vested in you, you become the beneficial owner and assume full authority and control over the said property. So you need not, it becomes your property, and you can decide to do whatever you want with it. That is how come when people say that, well, don't use this property for this when I'm no more.
Yeah.
When the property becomes vested in me, I can decide to sell it.
Yeah.
I can decide to do whatever I want with the said property. So clearly, when you are alive, you have to enjoy your money. Yes.
So when someone dies without a will, do you still need that early?
When you die without a will, yes. When you die without a will, then that means you have to apply to the court for letters of administration. If you die with a will, we go to court to probate your will. Right? Okay. Yes. So when you die with a will, the lawyers apply to the court for probate.
Okay.
Right. So it's almost similar to the application for letters of administration. Okay. The only difference with the two is that with the probate, you attach the will to the application, and the court satisfies itself with a copy of the will. Now, let me put it, if a lawyer executes a will for and on your behalf, it is normally done in triplicate, i.e. 3 copies. One is deposited in the courts, one is given to the testator to keep safely, and the lawyer keeps one. So in the event that the person dies, and the family members invariably know who the lawyer is, they go to the lawyer to inform him of the death of the said testator. Then an application is made to the court for the will to be read. Right? So it is the copy that is deposited at the registry of the court, for obvious reasons, is the one that is read.
Okay.
But they would always juxtapose the one that is deposited at the registry with the one that is being held by the lawyer, and sometimes the family members who might have come across the will in the closet of the deceased person.
How do you authenticate what is deposited at the court?
So it's a sealed document with an embossment
Okay.
by the registry. So it is not something that you can actually, after it's sealed, you can break the seal and try to make changes to it. However, the reason why in most instances people hasten slowly is that the law does not prevent you from executing more than one will.
Okay.
You can execute as many wills as you want, but the one that will be given effect to is your last will and testament. So if you executed a will in 95, deposited it in the court, and also executed a will in 2024, deposited it in the court, it is their last will and testament that would be relied on. Yes.
So this is a commission of oath. Can they issue an alien?
You see, the letters of administration is only granted by the courts after an application has properly been made before the court, and the court is satisfied under the circumstances that the persons making the said application are the right persons to make the said application. So a commissioner of oath may assist in preparing the application to the court, but it's the court that grants the said application. But I don't know why you would want to go to a commissioner of oath to because you see, estate matters are quite complex, and you need proper legal minds to actually take you through the process. So the lawyers will advise you appropriately if you meet a lawyer worth his while to talk about. He would make the application for you and also guide you after the application is granted. Because even in administering the estate, there are certain legal hurdles that you have to overcome. So basically, you would need a lawyer to help you.
So with the letter of administration, normally they bring you to the bank to check for balances and accounts. Do you have any idea how the bank confirm with the courts?
So as long as it is an order drawn by a court, having the court seal, then the bank are obliged to actually comply with the orders of the court. Now, most judges would require that you actually go for a copy. The court will draw an order requesting the bank to furnish the court with a copy of the balances of the deceased person before they even grant the letters of administration, because of estate taxes, because you are required to pay about 3% estate duty to the state. So most people undervalue the estate and get the letters of administration granted, whilst the state does not benefit. So in instances like this, the court would request for your balances, because ordinarily I, as a lawyer, might not know the balances of the deceased person. So I might, in my application, I might state that bank balance undisclosed, unknown, and if the court goes ahead to grant it, and there's about 10 million Ghana cedis sitting in the bank account, the government loses. So some judges now would always request a copy of the balances from the court before they go ahead to grant the early.
Okay, we'll wrap up with an advice from you. If someone wants to pursue a career in law, What should be the journey?
You might have a very strong conviction that you want to do read the law. It's just like any other profession. You need to have the calling and passion for it, because the journey is not quite easy, and it is only your interest or the conviction you have or the calling put appropriately, that is what will take you through this very difficult process of becoming a lawyer in Ghana. So it's a good profession. We need more lawyers. So anybody who wants to read law should take it up, pursue it with passion, and also understand that there are a lot of ethical obligations that is required of you as a lawyer. So most of the stories you hear out there is when you get in as a lawyer, you would understand that there are certain things you cannot ordinarily do. So you must be ethically sound to become a lawyer. And also you must have the passion. And you should averagely be a good and intelligent person to be a successful lawyer. So anyone who wants to read it, I've been able to do it, so anyone can do it. Yes.
Okay, then your last advice on will, if somebody wants to write a will.
Yeah, if you want to make a will, get a lawyer to advise you accordingly, because it might not, wills that not just take the form of giving out your property. It could be shares, it could be certain interest, it could be copyright. It's complex. Get a lawyer to advise you accordingly, and then let him help you execute a valid will, so that when you are no more, your estate would be handled appropriately. To be rather unfortunate that you, after toiling, working so hard, and you are no more, and then the people you indeed wanted to benefit are being deprived of an interest in your property just because you failed to make a will. And days on earth are not guaranteed. You never know when your maker may come knocking. So you shouldn't say, I'm waiting till I go on retirement before I make a will. The very fact you start working, if there are certain things on your heart you want done to you if you leave today, it doesn't prevent you from getting someone to assist you in making a will. Yes, but rather for most lawyers don't even have wills. Yes.
That's true.
Yes. So my advice is, it's a good thing if you want your affairs after your death to be managed and managed well. You should take steps to get a lawyer to assist you in making a will.
Okay. George, thank you for coming to Potbelly TV.
I'm most grateful. I'm very humbled.
It is one of the interesting conversations, and I'm sure you'll be back for more.
Yeah, most definitely. Anytime I'm invited out, do my best as a form of my corporate social responsibility to try and give and inform the general public about the nuances of the law. I would always avail myself to this channel, and also do my best to educate people on some lingering legal matters that they are confronted with.
Thank you.
Most welcome.
We had an interesting conversation with my lawyer friend George, and he talked about a lot with will. You don't need to be sick to have a will. You don't need to be broke to have a will. You don't need to wait to die before people be fighting with your properties. We've heard the stories. We've heard the misconceptions about will. Please go and do your will. This is Potbelly TV. My name, Mr. Jakwata.